Yes. Continue. State responsibilities. The next case I want to do very briefly is the Corfu Channel case. C-O-R-F, Corfu Channel is close to C-O-R-F, it's near to Albania. That involved Britain and Albania. What happened there basically was this. The Albanians had, well, I won't say the Albanians, but the waters, territorial waters of the channel, Corfu Channel, were mined. There were mines laid in the waters of the Corfu Channel. British vessels, naval vessels, were traversing the waters of the Corfu Channel and they were blown up. And Britain felt that Albania, and Albania is responsible. Even as a question of fact, they didn't actually see Albania, but they thought that given the circumstances, even if Albania did not do it, they must have known, they ought to have known that there were mines in the water. So they decided to take this matter before the International Court of Justice. Would Albania be responsible? Now, the court held that particular case, given the surrounding circumstances, they did not think that the mines could have been laid in the water without the knowledge of Albania. So they're not saying necessarily Albania did what they said. We don't think it was circumstantial evidence. We don't think that the mines could have been laid without the knowledge of Albania. And in light of this, Albania ought to have given notice to international shipping that the waters were mined. And in failing to do that, so not so much of what Albania did, is what they failed to do, omission. By not notifying international shipping, that the waters were mined, they were in breach of an international obligation. Yes?
Yeah, but you said it was warships, right?
Warships. Why?
Are they entitled to innocent passage if it's
No.
warships?
Wait. I said no, but it's a good question. You're taking us back to the law of sea now.
Yes.
Yeah. As you know, when we're dealing with the law of the sea, we did observe that this is a matter that can say probably is not very definitively settled. Insofar, some countries take the position that warships are not entitled to any right of innocent passage. They say the very nature of a warship precludes the idea of innocence. But of course, the major maritime powers, will always argue that warships are entitled to the right of innocent passage. And indeed, the convention itself just says ships of all states. It didn't differentiate and say warships as ships. So it's a question of how one wants to interpret this. When it says ships, are warships included?
Okay, so the Strait of Corfu, is that within Albania's
Territorial waters? Yes,
okay.
right.
So if that is the case, right, and you're a warship, and you want to pass there, and you know it gives the kind of thinking that, okay, it kind of precludes that whole innocent passage thing. I would think that they would have been in contact with Albania to say, well, okay, our warships are passing there. And then I think Albania should have said, well, you know what, we have mines there.
Yes.
But you just pass there on your own accord.
Good.
Right?
Yes.
So
I appreciate your line of reasoning. However, you see, if you think you're entitled to something, it may not be the best thing to, if you like, give the notice because they would feel, well, they've always been giving notice, especially if the countries probably do not enjoy, and indeed at the time they were not enjoying friendly relations. So they say we have the right and we pass it. We don't have necessarily to tell them anything. It's a right which we have under international law, and we are exercising that right. But again, you have a point. In most cases, when warships are going through the territorial waters, the coastal state would be informed that they
Exactly.
anyhow.
So you breach my sovereignty.
Waters were some. But if I say that I have the right of innocent passage, maybe I'm not really in breach of it.
You're a warship.
I know I'm a
And
warship.
we are not friends.
I do not think it. But all right. I've heard you on. I've heard you so in that case, there was this omission as far as the in terms of the facts, circumstantial evidence that it ought to have known and did not inform international law. So they said basic considerations of humanity would have required Albania to notify international shipping. This is what is mine. Now,
So is that like the same thing with trespassing down here, that you owe a duty of care to trespassers? In a sense, because to me they trespass on Albanian territory.
Yeah, but remember with trespassers now when you're notified, there is a sign of trespassers will be persecuted or whatever.
Yes, but even if it is there, is like, let's say they say like if a child goes onto your property, maybe the child can't read the sign or something, and they end up on your property and they're damaged. Aren't you liable as the
well, yeah, well, it depends again. I mean, sometimes there's exactly. There are times when you're supposed, anybody who probably could come in, you're supposed to put this notice up. That is why sometimes you will see notices up, people, anything dangerous.
Yeah.
Even in your yard,
Yeah.
dangerous dogs.
Yes.
Yeah,
But that is not what Albania
but-
did. Albania didn't.
But okay,
notify
it's like
them.
it brings to mind this case where there's this man, bandits kept robbing him and he booby trapped his house or something like that,
Yes.
and one of the bandits got
Yeah.
injured and he was liable.
Oh, yes,
I find it so stupid.
yes, quite right. No, quite right. Because in a sense,
You are infringing on my property and my security.
damage to him.
I did not tell you to rob me. Did I hold a gun to you and I tell you to rob me?
They didn't have,
No, but it's
they
like
didn't have
this.
any indication that he has these
If you notify me
traps.
that you have a pit bull in your yard, right? And let's just say rain falling and your yard exposed and I walk onto your property to shelter. And your pit bull attacks.
You walk onto the property.
Okay.
You're my
Wait.
You're trespassing one, but the bandit
I'm
is
not.
Wait a while.
going to run.
Anyhow, we have to move on.
I should be responsible that you all lost.
So we've been looking at situations where, by way of diplomatic protection, the state has been intervening on behalf of its nationals in foreign countries. And I say on behalf of its nationals. In other words, a state can only intervene on behalf of an individual if that individual is a national. In other words, it is by virtue of the bond of nationality that enables the state to intervene. The individual is not a national, but the state can. It must be established that there is a bond of nationality. Now, very briefly. No, the state is not obligated to. The state is deciding that it is supposed to intervene. It's not obligated. But, yes.
So, Mr. Francis,
Yeah?
Russia, when Snowden went to Russia, right? Even if Russia wanted to have some protection of Snowden, they couldn't intervene on behalf of Snowden, right?
Well, no, because Snowden is an American citizen.
If you want asylum.
So,
Well,
you
he's
want
an-
to take it, he is exposed, nobody can protect him.
No. He is exactly. He is seeking what call it asylum. He's seeking whatever it is he's seeking. He wants to be in Russia. And Russia has agreed. Yes, we will in. It's as simple as that. Now, if say, for example, if you were to leave Russia and it suffers in some foreign state, Russia cannot represent it. It would have to be the United States. Because he's an American. He's a US citizen, United States citizen. Yeah? Yeah. And of course, once the Russians want to admit him, it's their territory, they could admit him. And he's there. He's an alien. This is the point there. So if they mistreat him, treat him badly, then of course, I suppose it will have to be the US to become part of it. So the point we're making is that individual who has suffered injury in a foreign country, alien, has to be a national of the state taking the matter by way of diplomatic protection. Now, nationality is not determined, let us observe that very quickly, is a matter for domestic law. International law does not determine the issue of nationality. It is a national law. So all of you here are citizens of Trinidad and Tobago. You are nationals of Trinidad and Tobago because the laws of Trinidad and Tobago say that you are national. And there wasn't anything that you had to do. You were Trinis at birth. You didn't have to do anything. Your parents didn't have to do anything. Because the law says, regarding citizenship, says people who were born here, this is what you refer to as the lex, yeah?
So then how come the Dominican Republic can say the Haitians that were born in Dominican Republic can't have
Well, again, as we said, it's a matter for, you may not agree with the law, I don't agree with it, but it is their law. It's under their law that they are saying that. Now, we will take strong objection, even on grounds of human rights, depriving people of citizenship, because some of them have become stateless. And this is the importance of having a state, having a nationality in international law, because if you're stateless, in a sort of cases that we have just outlined, there is no state to step forward on your behalf to provide any sort of diplomatic protection. And you are deprived of enjoying a lot of rights and so on, because you simply do not have a state. In the state where you are, physically, in a sense, you don't have any rights, any great rights, a right to this, a right to that, yes? Rights that they confer on nationals you wouldn't enjoy, because you're not a national. But in the final analysis, it is a matter for domestic law. But it does have international implications. So for example, on grounds of international law, we can condemn what the Dominican Republic has done to say, well, this is in violation of human rights. Depriving people of, because some of them already, I think, had Dominican citizenship that has been taken, they've been stripped of it. Yeah, so, but it's a matter for national law. So Trinidad says, people are born here. The legs, the juice, soil, you were born. Law of the soil, law of the land. You were born here. Or, one of your parents at the time of your birth was a Trinidad and Tobago national, what they refer to as the Jus sanguinis, descent, blood. Sanguinis means blood in Latin. So, the blood. So, two basics for citizenship. Birth, at both, birth, and a parent. Well, in most of your cases, it will be on both grounds. You will be born here, and your parents will be nationals. Yes? So it means that if you're in a foreign country, mistreated, Trinidad and Tobago can intervene on your behalf. You can go to the consul of Trinidad and Tobago, the embassy, whatever it is, and complain and say this is Now, although we have just said that nationality is a matter of national, in an important case, not a bold case, Nottebohmn, not Bohmn, M as in Mexico, MN. Not
Nottebohmn as in man, and
M as in man, and N as in Norway. Yes,
Okay.
yes.
Don't confuse me there. What?
Not be confusing.
Not
It's Miss
Born.
Remy. Is Rowena confusing me? Spell the thing correctly, and she's throwing you all over the place.
Not the
You see,
N.
Not
Not
M as in man, and N as in none.
MN. Not it's a German. It's German. It's German. Not what does that mean? That was a dispute between Liechtenstein and Guatemala. What is the problem? Nothing. Left Germany and migrated to Guatemala. Quite a number of years. He resided there, doing well for himself. Some migrants do very well. They work hard, some of them do well, they make money. Just around the time of the outbreak of the Second World War, Nottebohm started becoming worried because he was German. And if Guatemala had declared, say for example, to enter the war against Germany, that would have made Nottebohm an enemy alien. Have you ever heard the term enemy alien? Meaning he is alien in the country from which he comes as an enemy. And that would mean that you're deprived of a lot of your rights. If you remember in the States during the war, they held a lot of Japanese, put them in camps. Yes? Enemy alien. That's right. Now, Nottebohm said, I don't want to be an enemy alien. That means they will take his property. So he decided to travel, he had a brother there, to Liechtenstein. Spent a few weeks there and acquired, became now naturalized, become naturalized, an individual can become, acquired the nationality of the country. You were not born there, your parents were not born, but country will say maybe years of residence, blah, 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 blah. Anyhow, you became a naturalized Liechtenstein citizen, naturalized. And then, having acquired that nationality, Liechtenstein nationality, traveled back to Guatemala. All the world is, I am now a citizen of Liechtenstein. I am not German. The Guatemalans were not impressed and still treated him as a German. After all, he couldn't just leave and in mere weeks become citizen of Liechtenstein. But remember, we said that that is a question of citizenship. Liechtenstein's citizenship is a question for Liechtenstein. But Guatemala still regarded as German. Proceeded to seize his property. He appealed to Liechtenstein. He's now a national of Liechtenstein. He has documents, naturalization documents. And Liechtenstein decided to take up the matter on his behalf, saying to Guatemala, this is a citizen of our country. Look at how you have treated him. And therefore, we, on the international plane, are prepared to prosecute his claim. That's what they were doing. So far, so good. Can be. Decided, luckily, Liechtenstein and Guatemala to submit the dispute before the international court. And the matter went before the court. Before the court, Guatemala pleaded that this Liechtenstein citizenship should not be recognized by the court, given the circumstances in which that nationality was obtained.
Exactly.
Okay, you say exactly. As I said earlier, nationality is a matter for the country conferring the nationality. It doesn't fall within the purview of international law, although it has international implications. Well, the court went on recognizing the truth. That's what I've just told you. It is the state that will have to determine who its nationals are. And Liechtenstein decided that Nottebohm is a national of Liechtenstein. He has his documents. But, they said, for the purpose of bringing a claim on the international claim on behalf of Nottingham. They are saying that there should be, that was a new thing, a genuine link. They introduced this doctrine of genuine link. There should be a genuine link between the individual and the state. Heretofore, you simply looked at the documents presented to you and said, yes, it is a national. But they went a little beyond that and looking for a genuine link. Now recall the circumstances in which he obtained Liechtenstein nationality. He did not have any strong bonds to Liechtenstein. He did not reside there for any considerable period of time, as I said, mere weeks, and he obtained. So the court said, for the purpose of diplomatic protection, they're saying that there should be a genuine link. And therefore, Liechtenstein would not be able to bring any claim against Guatemala based on the doctrine of genuine link. Now, you agree? Of course, that has been criticized by some commentators. Because as I said, heretofore, the country conferring the nationality, its word, its decision was conclusive. He is a national, he is a national. In that particular case, the court was saying there was no genuine link. So this is where we are now, the genuine link doctrine. You remember when we were dealing with the nationality of ships, you remember? Where the relevant provision in the convention said there must be a genuine link between the state. Well, they got that from the Nottingham case. They got that from the Nottingham case. So they took this bad precedent and incorporated it into the convention. But this was what was decided. They're looking for the doctrine of genuine link. Before that, yes, genuine link was used only in this limited sense, in a situation of dual nationality. For some people have dual nationality. Yes, it could be stateless, you could have dual nationality, depending on the condition. So, dual nationality, they will say, well, okay, who should represent you? Which state? And they say, in that case, they say, well, you wish to have a genuine link. Maybe where you reside, where you carry out your business, where you vote, and so on. That was not the case there. Nevertheless, the court said genuine link doctrine. Not in all cases. So it's an interesting case, right? There's another one, quickly, the Barcelona traction case. Barcelona traction, TRACTI. Power, they were providing power company. Power company. It's a company. A company that was registered in Canada. The majority of its shareholders were based in Belgium, conducted business in Spain. And as a result of action of the Spanish government, that company suffered considerable losses. So, which company should be represented, which, in terms of diplomatic protection, which of the names that I've called? Canada, yes. Canada, yes. Why? Because it is a national of Canada. It was registered there. But Canada was not too interested in the matter. And Belgium, by virtue of the fact that the majority of shareholders were from Belgium, decided to prosecute the claim on behalf of the company. What do you think?
They can't do it on behalf of
Does
the company. They can do it on
Why not?
because
Why
the
not?
company is Canadian. They can do it on behalf.
Yes,
Yeah.
yes, yes. And in law, the company has an existence
Outside of
separate and distinct from that of its shareholders.
Exactly.
Belgium only had shareholders. It's only if you fold up, the company has been folded up, If it ceases to exist, then the issue of shareholders rights will come, or maybe payment of dividends or something like that. But in terms of the company's operations, companies sustaining losses, it will have to be a matter for the state of which it is a national. So Canada did not come forward. So therefore, that claim was not admissible because of the fact that Belgium was not a state of nationality. Shareholders, yes, most of the shareholders. But while the company is in existence, you are not willing, Rowena, to lift the corporate veil, as it were, to look to see how shareholders are. Because the concept, and if you want to do that, a big company, you have shareholders scattered all over the place. So it could be this state, that state, this other state, this and that. That's exactly that. You see, that's confusion. That's chaos. Let us just see. It will have to be the state where it is registered, the state of which it is a national. In this case, on the facts of the case, it was Canada. And of course, as we said, the state could decide not to do it or to do it. Nobody can force it to. We have the right, but we may decide not to exercise the right. In that particular case, Canada decided it was going to exercise. Maybe there wasn't anything in it for Canada because what? Canada didn't have any great interest in the matter. That is a matter for Canada to determine. That's right. So, but remember, in terms of genuine link, if you were to take the genuine link established in the Nottingham case, you say, well, why Canada? What is the genuine link? It was just registered there. But its shareholders, the place where it conducted its activity, it was in Canada. So in what way was there, if you apply the genuine link doctrine, how is there that genuine link between Canada and the company? Are you seeing it? They conduct its business there. Its majority of its shareholders were not there. Blah, blah, blah.
Then you should have registered
But
in the country of your shareholders then.
Well, okay. What you know sometimes for tax purposes, whatever.
Well, right, so then it shouldn't be complaining.
It shouldn't be complaining. Okay, I agree with you, Amanda. So that is the. So these, in a sense, you could say these are procedural issues because a state may be coming forward. But the claim itself, before the court gets into the merits, remember in these two cases, they didn't look to see what the state did there. They just didn't entertain the claim. In the case of Nottingham, they didn't find a genuine link. So the claim, you would say, was not admissible. Meaning, we're not going to consider right and wrong. Should we be seized of the matter? Should we go on to hear the claim? Because these are preliminary matters. You haven't really come to the point where you're examining the rights and wrong, the question of liability or responsibility. Should you admit it? That was an issue dealing with. It's a preliminary matter. But if you follow cases here sometimes, you deal with a number of preliminary matters before you come to the heart, the core of the dispute. And sometimes the court will throw anything out on some procedural grounds. Yeah? Even without considering the merits, what you call the merits of the case. In other words, did Spain do wrong? The court doesn't even go in there. They said, first matter, because
Do you even have a case?
Spain raised it. That's right, exactly. Admissibility. Another one dealing with admissibility is the question of exhaustion of local remedies. We said all the cases dealing with the state responsibility. The state, if you like, embracing the claim, exhaustion of local remedies. What does that mean? Well, what do we see? What that means is this: because the state now is stepping forward on behalf, championing as it were, the cause of its national, seeking to provide diplomatic protection. See, our national has been wronged. He has suffered as a result of your breach of international obligation. Taking the matter up. But before it does that, that national must have exhausted local remedies. How do you exhaust local remedies? An educated guess. How do you think you would exhaust local remedies? Quick. We have to finish this thing today. Nobody could hazard a guess. good educated guess?
You
No?
would say, diplomatic missions or something like that?
Well, not so much diplomatic mission, not so much diplomatic, well, yeah, they have gone to the diplomatic mission insofar as they want the state to intervene, but not so much that.
Just referring to the local, in the state where the person is residing, whatever local mission there is there, and the country's mission.
Why you say mission? Why you on about mission? Would the mission provide, would the mission be able, would the consulate be able to provide you with the remedies?
What are you
Seeking damages, you say, huh?
Okay, so is it that
Think of remedies, think of remedies. What remedies, what form do you think the remedies would take? Quick. What form?
you have gone to the authorities responsible?
Which authorities? Which authorities?
What did it
The courts, yes. You go, the individual goes before the local court. Because if he succeeds, they would have awarded him damages. So this is a remedy.
Right.
Yeah? So he must go there first. Yeah? Usually before the local courts to exhaust the local remedies. You give the state, you see, against which a complaint is being brought, an opportunity to put its, as it were, its house in order. You see. So we do provide remedies. Why should we go to the international plea when remedies were available? This is what we have court. We have an independent court. He would have appeared before an impartial judge. What's wrong with that? Why do we want to go there for international plea? Why do we want to live here and go elsewhere when everything that you possibly could want, you could get it here? This is the rationale, you see. So therefore, you see, exhaust your local. This is a well-established principle. Again, it is a preliminary matter. The state against which the dispute is brought can say, well, wait a minute. That individual whose claim you are prosecuting never came before our court to seek remedies. And remedies were available. Remedies galore. Yeah? Remedies galore. You can get everything you wanted. You can have got $1 million, tens of millions of dollars in damages. But he chose not to run straight to it. So you see, clearly, exhaustion, meaning you go before the court. And not just going before the court. Yes. But you have to avail yourself of all the procedures that will exist. So if, say, for example, it may mean, that could have made a big difference to your case, calling witnesses, for example. A witness whose evidence could have been vital to your case, but you chose not to call that witness. It may also mean that you may go before the court of first instance. Court of first instance. What? Amanda? Appeal. There is appeal available. But you chose not to appeal. So they will say, well, and that's the whole thing. You have not exhausted everything. Because yes, you come before the High Court. But we also have a court of appeal. So maybe if you have gone before the appeal, the court of appeal, the court of appeal may very well have reversed the decision of the court of first instance. Yes, Bishop? So you have to go from stage to stage to stage. 1 and 2, you have to avail. They say, for example, you have to produce certain documents, certain this, certain that, procedural matters. You have to make sure that you avail yourself of all these procedures. If you didn't do that, then the defendant state, the respondent state, they say you did not exhaust local remedies. In the Ambateros case, very quickly, a case between Greece and Britain, where Ambateros is a Greek, and he was claiming that he suffered damages as a result of the activities of the British government, and appealed to Greece. And Greece, of course, espoused his claim. But Britain said he did not exhaust local remedy. That involved the calling of a witness. So sometimes not just appearing before the person, but also availing himself of all the procedures that are available to him. Yes, exhaustion of local remedies. If not, your matter will be struck down if you didn't exhaust. These are preliminary matters, procedural requirements, but they are important. Nationality, exhaustion of local remedies. And there's one further thing that I have to introduce to you. Again, in your reading, and I hope I'm not being presumptuous, but in your reading, Mando, in your reading, you'll come across the Calvo doctrine. Calvo, C-A-L-V-O. Calvo was a foreign minister in the 19th century of Argentina. Carlos Calvo. Incidentally, especially in the area of state responsibility, what one sees sometimes is a Latin American position and sometimes the position of the Europeans and so many major powers. It's easy to understand because, of course, at one time, all the newly independent states were Latin Americans. We weren't around yet. So they were the ones, in a sense, who were, if you like, questioning a lot of the traditional international law principles. So the Latin, there's always a Latin position. And they develop certain doctrines in trying to protect themselves, if you like, against the international law existing at the time of the 19th century when we became independent. So this Calvo, what he did was this. If foreign investors were coming into Argentina, okay, started with Argentina, but what his doctrine later was adopted by other Latin American countries. He said he entered into an agreement with them that in the event of a dispute arising out of the investment, they would not resort to the country of which they were a national, but would have the matter determined by the court of Argentina, by the national court. In a sense, national treatment. You're not supposed to get anything more, anything additional to what nationals will get. So you come and you subject yourself to the national court. Don't go to the other courts. And that was part of the agreement, written into the investment agreement that he entered into with those countries. So if you like, he did not want to internationalize the agreement. Let it be local, let it be a national issue. This is, but that has been questioned by the developed countries, the capital exporting countries, because they say the right to represent the individual is not the individual's right, it's the state's right. The state is the one determining whether or not we are going to intervene. So they say you can't, by agreement with the individuals, in that case investors, take away from us a right which the law, international law, confers on us. See? We're not recognizing that has no validity. But the Latin Americans stood by Calvo, stood by it. So the Calvo doctrine. What you say, it's purely a national matter. It's the advantage of investment dispute. It's a national issue. So to be determined by a national law. Yeah, that was it. But as I said, it's controversial. It's exactly. Now, so that was Calvo. Now the next thing that we have to do very quickly, expropriation. We're not doing too much. Expropriation or nationalization. What do you mean by expropriation or nationalization? Don't write, just listen, just think. What do you mean by expropriation or nationalization? Yes, yeah. What? Laurie didn't hear you. Laurie did not hear you. Was that only me you're talking to? Did you hear Laurie? She was speaking very quietly to me, but she wants to hear.
It's the case where a government takes possession of the assets of a foreign company that is operating in the state.
Yeah. Well, not necessarily even foreign. I mean, it could be any company. And the idea of nationalizing, expropriating. the compulsory Good morning, Miss Song. How are you this morning?
I'm good.
Okay.
How are you doing?
Not about that. The compulsory taking of property by the state. The state is acquiring property of individuals, companies, in case maybe. Taking it. Now, but we are concerned when they're taking, of course, for the purpose of international law, for foreigners, as well as foreigners.
So like a key.
Yes.
And it's a really
That's right. You capitalist, owning all these things. A socialist government, so we take everything and bring it under the control of the state. Done with capitalism.
Yeah,
Well, it could be a democracy too. And you decide to nationalize, but it's more common among socialist countries. As a matter of policy, you see, the state has a right to intervene, to own, to distribute and everything. Yes? Especially huge, large operations. It's an ideological issue. And that takes in sometimes almost on a collision course with international capital. And the states representing them. Expropriation. Now, can the state take property? Does it have the right to take property? Because usually it will have the law, it will pass a law, enact the legislation to take the property. But can it take the property just like that? Yes. Compulsory? Yes. Yes, it has the right, yes. Okay, step by step, we are agreeing, we are accepting that it has the right to take property, for example. But can it just arbitrarily or whatever it is, just go and take property? Take property? No, 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 no. Well, what are some of the things we think, some of the requirements you think that should be satisfied, that should be met if the property is being taken?
Well,
you're not necessarily questioning the right of the state to take the property, which you probably might be saying, but at least certain requirements must be satisfied. Certain standards should be.
Questioning the procedure.
What are the requirements? Just take it. If your property is taken, for example, what would you expect? It's your property. You own. That's right. You would want compensation. That is one of the things. You say, yes, you can take the property, but I want by compensation. So this is one of the issues. Any other issue you could think of in terms of requirements? Even while acknowledging the right of the state to acquire, to nationalize, to expropriate.
Relocation of the goods, not part of compensation. But if you're taking my property, then you have to find somewhere for me to go.
The reason?
Well, I compensate you. I don't necessarily find somewhere for you. I compensate you.
Well, you move with me.
I compensate you.
Compensation includes relocation.
Well, maybe here, yes, here we tend to look and say, well, we would do that, we relocate. And I suppose in a lot of cases, for political reasons, they say, yes, we have to find a place. If not, in the next election, we will lose votes and so on, blah, blah, blah. But from the point of view of the law, of course, you will have to get your compensation. What again was in the state?
It must be for the national interest.
Yes, yes, a public purpose. You would say yes. The state may have, say, for example, you want to build a school, a hospital, or a highway from San Fernando from south to Point Fortin. Well, you have to take property, don't you? You can't build it in the air. So you have to acquire property, expropriate it to the state in order to get the highway built. Yes? So you say, but you see, these are the things you might say, okay, for a public purpose. Compensation, yeah? And you may say for, without maybe discrimination, taking all the property in this particular area there, taking vishals and go around and then you take lorries. Now, that is, so we are able to see the things that we have mentioned: compensation, for a public purpose, no discrimination. So you can't say we're only taking the property of people with blue eyes and that property people with brown eyes. You can't say that. Or we only thinking of this people of so and so origin and not those of some other origin. No discrimination. Yes, Laurie?
Yeah.
Good. Now,
Can it be, like in the case of, for example, if the government decides they want to do a development in an area and it may expose residents to danger, can they relocate them because of that, even though they may not be using their property as part of the development?
okay, when you're too close, so you say, well, we still have to move.
Relocate.
We're building a dam, we're building
For hazard
something like
purposes,
that,
yeah.
yes, there could be hazards. Yes, I suppose. So, yes. Well, yes, as a government, we have to move because we cannot have people living so close to that particular area, given what we're doing, it's too close to this thing. Yes, yes, a government should. But, well, again, you're necessary to take particular measures for their own protection. Yeah. Now, that is, we just look at it at the national level. Now we're moving from the national level, but what we're saying at the national level may also be applicable at the international level. But, listen, see things like for public purpose, for this and for that. Again, you have some countries, again, there is not necessarily agreement, or if you like, unanimity or consensus sometimes on some of these matters. Because some states may feel, we speak about compensation. Now, if you're taking maybe 200 acres of land, 300 acres of land, you might be doing compensation, yeah, in terms of market values. But, supposing it's widespread, my government will be taking over the banking industry. It will be taking over the shipping industry. It will be taking over this industry and that industry. Visually, just about everything is going to be national. Just as it used to be in what used to be the Soviet Union, or as it is in Cuba now. The state owns, the state has made an intervention, and as a matter of policy. But in terms of compensation, will they have the resources to pay? So you may have to settle. Now you want your compensation, you're probably going for market value.
Mm-hmm.
Yes, that's what you would want.
Yeah.
Under international law, there is no way they could really pay market value. You're taking over the entire, what is it, what industries? The rum industry, this industry, that industry. The state would never satisfy it. Even if they say that something should be paid, especially to foreigners. And in a lot of cases, the foreigners will just about everything. So, oil industry. So, Trinidad and Tobago, you want to take over the entire, all of the oil industry. BP, whoever else is here, you're nationalizing. In the 70s and 80s, we used to say owning the commanding heights of the economy. You ever heard that expression? Particular development. Must own the commanding heights. Sounds nice, though. There's a nice ring to it. Must own the commanding heights of the economy. We must have banking. We must have insurance. The state. The only problem with this is that the state can't do anything. Oh, you're laughing at it. The state cannot do anything. When I was young, I used to be saying that, but now, given what I have seen, what I've observed, I realize that the state has been a mess of a number of things. There's a time in here in Trinidad and Tobago where lots of things were owned by the state. Electricity, telephone, all the utilities, they had Carol in 1975 limited. What's the story with all of that? Losses. Enterprises that should be bringing in money, you have to go to the treasury instead of getting money to keep them. That is the experience of the state. Yeah. So, good deal. I mean, commanding heights has a nice ring to it. Owning the commanding height. But our experience, let us be honest, wasn't a good experience. For the simple reason that you have to learn to run the thing as an enterprise that should make money. Vishal wants to put his friend. I want to put my partner. That's going to happen. Are you going to make money? You're going to make profit. And then when you can make a profit, you're taking money from the treasury. Money that should have gone to building roads and looking after the hospitals, you have to take it up and put it in a company because it's badly run. That was our experience. I'm not thinking anything. eventually we divest it. So privatization, especially when the IMF comes. The IMF says all this private. Yes?
Mr. Francis, so in terms of expropriation, a good example would be in Venezuela when they nationalized all of the oil industries.
Yes. Yes.
These companies, I don't know if they were compensated or not, but even if they felt they were not adequately compensated, they couldn't really take it up to the International Court of Justice because of the Calvo doctrine, which stated that they needed to exhaust local resources first.
No.
Well, local
yes, yes. And the Calvo doctrine, of course, is something between the individual investor and the thing. But remember, if you're talking especially of the International Court of Justice, you're looking at the state, because the company has no locus standi before the International Court of Justice. No individual, no company, private company, can take a dispute before the International Court of Justice. It is states and states alone. That is written in the statute of the International Court. Because you see, feel like it's a hangover from the old days when you say only the state is a subject of international law. Yeah?
Even if they try to argue, for example, U.S. national companies, that because the company is seen as an individual, they can argue for diplomatic protection.
Yes, that's right. They can go to their country. So if it's a U.S. company, they can go to the United States, and the United States will intervene and take up their claim. I don't laugh. This is one lady who is always very, very early. So there must be very unusual circumstances for her to be coming. Very unusual. See, I'm defending you. Very unusual circumstances why Samantha is going to come at this time. She and Vishal are the most faithful students. It's nice having you anyway. Okay. Good. So they will be coming. And they will be saying just what we said. You have to compensate. They may not necessarily tell Venezuela you can't take the company, but you must pay compensation. And guess what? They won't just say compensation. You say compensation. Well, you can't again, you can't just say compensation. What's sort of standard? How would you assess the compensation? How long should it take you to pay the compensation? So would you just give me bonds? Or give me useless bolivars or whatever it is? I don't want bolivars, what am I going to do with it? It's like monopoly money. It's not hard currency. If you give me that, I have bags after bags after bags, whatever it is. Well, how am I going to spend it? If you give me good currency that I can use, that is convertible. Yes? So these are some of the issues that arise when we are addressing the issue of compensation in a legal way. So what the Americans will tell you, the Americans, looking for the American companies, they wouldn't challenge your right. And I think this right to nationalize is established. You can't say the state is wrong. But as I said, it must observe certain requirements. So, and you, together, both sides, this side and that side. We agree. We say there must be accompanied by compensation. It must be for a public purpose, and it should be without discrimination. We agree on that. But it's easy to state it, especially the issue of compensation. You can't do it. Well, you have to pay compensation. But how would you determine the compensation? You have taken over my company. You have to pay me compensation. Just give me something like that. How do you assess it? What standard do you use today? Now the Americans would say prompt, as the Americans say, adequate and effective compensation. They qualify it. You just told me compensation. But the American will be saying prompt, adequate, and effective compensation. That formula was first stated by a U.S. Secretary of State in the 1930s. In 1938, Cordell Hull, who was the U.S. Secretary of State, said yes, especially with respect to Mexican nationalization, U.S. policy, must be accompanied by prompt, adequate, and effective. What do you mean by prompt? Well, prompt is something not very specific. But at least, I would think, within a reasonable period of time, we should settle on the quantum. Prompt. I can't just take my book and I just sit down waiting. Prompt. adequate. What is adequate? How do you determine adequate? What is adequate?
It's equitable in some form. In value.
Well, you say equitable, all right, but equitable, yeah, okay. Equitable. Any other thing you can say that would help us
The
to
value of the asset.
Okay, yes, you see, you're coming closer now. You see, you're coming closer. The assets, you're taking up assets. Assets have a value. Yeah? But how do you determine the value of the assets? There are a number of ways how you could determine the value of assets. How do you determine the value of the assets?
You audit it.
What criteria?
You audit.
Audit? Okay, yes. By what? Try to arrive at what? The market value? How do you determine market value? Do you take into account future profits? See, all these issues. You see, if you're the businessman, these are the kind of things, this is the way you are here. It's not just looking at the assets and just do a calculation. But remember, you're taking this thing as a going concern. So therefore, if you're taking it over as a going concern, how much profit are you going to future profits? But that would mean now the value getting higher and higher. So I may just want to say, let us evaluate, get a value on the assets. Bring in the accountants, bring in this, bring in that, and let us get a value on it. And I'm saying it should include, so I as the owner of the property, it should include future profits. You're saying, no, just let us get a value on the assets, the machinery, the this, that, and so on, the lands, buildings, everything. Yes? So it's what I say that we're making this point to underline the fact it is a highly contentious issue between capital exporting countries and capital importing countries. So the capital exporting country will come and the company will say prompt, adequate, effective. Effective meaning that you have to pay in a currency that the foreign enterprise, the foreign entity will be able to use. You can't pay in Trinidad and Tobago dollars. It's no good to anybody once you leave the shore. It's no good to anybody once you leave the shores of Trinidad and Tobago. Trinidad and Tobago dollars is only good in Trinidad and Tobago. But I can't take it and go in a bank with it there. They chase me, send me out, send me out. We don't want Trinidad. See? It's not convertible. It's not convertible. Yes, Samantha? You want currency. That's what you mean by effective. I must be able to use it. You give me bonds. Okay, yes. But the bonds will mature probably over a period of time. How many years? In terms for the bonds to mature? No. 10 years, 5 years. But remember, especially if the value of what is being nationalized or expropriated is very high, the state will be hard pressed. So I've given you what is a classical approach: prompt, adequate, and effective. Typical American position, especially. But as we said, in terms of practice, sometimes the matter is settled on a lump sum, because there is no way sometimes that the state nationalizing can pay prompt adequate. So they would give the state to which the company belongs, and sometimes it's not just one company involved either, it's a few companies. It could be Texaco, it could be Shell, Chevron, whatever. And they say, well, all right, we'll give you that amount of money that you will distribute among the various entities whose properties have been nationalized. Yes, Samantha? That's what it referred to, you see, in your as lump sum payment. So I've paid. Lump sum payment. Well, for you, you're happy to get it. It's better than nothing. Sometimes, Amanda, it's good to cut your losses. You argue with me too much because you won't get anything more. So maybe I give you what, 60 cents in the dollar? I can't give you dollar for dollar, maybe 60 cents in the dollar, given the size of this thing, especially what we did with national widespread. Or nowadays, so this is so the point we're making is that the customary law position has been a little uncertain regarding the issue of compensation, the taking of property. Yes? And where we say, well, and very often too, the capital exporting country will be arguing that it's an international matter. And maybe the capital importing country, the country where the nationalization is taking place, may say, well, it should be a domestic matter, we should deal with it at the domestic level. Don't internationalize it. But always remember, especially in terms of foreign investment, because expropriation is usually the area of generally foreign investment. And when you're dealing with foreign investment, there are two things. One, you will have an agreement between the state and the foreign company. So for example, pt2 is exploring for oil off Guayana, out in the Atlantic. Yes? pt2 is out there looking for oil as a result of an agreement between itself and the government of Trinidad and Tobago. But if we ask the citizens, nationals, to see this agreement, they will never show it to us. We will never know. Take me and trust. There is such an agreement. A big company doesn't come in and put in millions and millions and not millions, but billions of dollars into a country without the citizen. But they never. The company doesn't want you to see the agreement.
Well,
the state doesn't want you to see.
As a citizen, why we can't see?
They don't. The company itself doesn't want you to because they say that it may give an unfair advantage to their competitors. So they don't want to see. They don't want you to see it either. And I am not too sure that you might be able to get it under the Freedom of Information Act. So you can try your best. Yeah.
I believe one such agreement was probably if it wasn't last month or sometime
Okay.
in recent times.
Yes.
Probably having the rhinos and leading to being upset about that.
Exactly. They don't want us to know, and not only Trinidad. This is not peculiar to Trinidad. Generally, the host state would not want the contents of the agreement to be known. The company doesn't want it to be known. So this is where they work on the thing. So even if it's a sweetheart deal, we would be none the wiser. So this is it. But these agreements would provide for a number of things. What should happen in the event of a dispute? They may agree, okay, maybe we'll submit it to arbitration. How should we assess the value and so on? It will deal with all these issues. The states and the capital exporting countries themselves enter into bilateral investment treaties with a number of, say, developing countries. So I'm sure that you will find the United States and Trinidad and Tobago would have a treaty, a bilateral investment treaty. Just as how you have trade treaties, so too you have bilateral investment treaties, where again the treaty would provide for the whole issue of foreign investment and in the event of nationalization, how this matter should be treated if there is a dispute, how the dispute should be resolved. So you have that instrument. The one between the state contract, state and company, but you may also have the country itself, US, Trinidad and Tobago, bilateral investment treaty. One should have a number of clauses addressing a number of issues. Because over the years, you see, one would have seen the kind of problems which arose and they tried to deal with it. The only thing, of course, regarding these bilateral investment treaties is that often bilateral investment treaty. How do you think this? No, very often it would be the US itself, or France, or Germany, countries that are exporting capital, who would come with a draft. They already draw the treaty. Yeah? And whatever negotiation takes place would be taking place on the basis of the agreement with the company. This is why, if you look at bilateral investment treaties, there is a sameness about them around the world. And you have a series of such treaties, in a sense reflecting the position of the capital exporting country. Your US, your France, your Germany, your Britain, and these countries exporting capital. So you feel like it's very favorable, biased, prejudicial in favor of capital, because you have to protect capital. Well, Amanda don't talk anything like that. That is what capitalism is. You have to protect capital. Yeah? So, quite apart from these common customary law principles, over which you have a lot of debate and so on. States have gone a bit further. They have been able to conclude these bilateral investment treaties. And of course, the company, the state and the company itself would have entered into these agreements. So we have these issues. So what was a bit unclear, uncertain? Once you have a treaty now, it's really much clear. Any question? Any comment? One final thing, just before we open. Are you laughing at that? Okay. One other thing that I have to say before we, on the issue of expropriation and nationalization, you should know that there exist two important General Assembly resolutions. One in 1962, one is permanent sovereignty over natural resources. In other words, I want to say basically that resolution is that you're acknowledging, you're recognizing that states have permanent sovereignty over their natural resources. That was in 1962. And there was a later one that more or less covered the same ground, but provisions are somewhat different. The Charter of Economic Rights and Duties of States. And the difference, mainly, the latter document, the Charter of Economic Rights and Duties of States, it is less, as with respect to nationalization, it is less circumscribed. It doesn't go into things like no public purpose and no discrimination. It is silent on these issues. And in the case of compensation, it simply says appropriate compensation, not very specific. Well, of course, the 1803 resolution also says appropriate. It doesn't say prompt, adequate. But as I said earlier, if you're dealing with the United States, they would say appropriate, prompt, adequate, and effective compensation. And one final thing, as we spoke of customary international law, I should let you know that the International Law Commission, I should have told you that earlier, but I'm telling you now, it either comes at the beginning or at the end. The International Law Commission, we have come across that before. Don't tell me you've never heard of the International Law Commission. Yeah, in what? We're dealing with what? Law of the sea, what else? No. Law of the sea, you're quite right, the 1958 conventions, the International Law Commission worked on these documents, yes?
Human rights, they also...
No. Anyway, we don't have much time left. Law of treaties. Law of treaties. So when the states went to negotiate the law of treaties, they had a document. Each delegate had a document that was prepared, a draft treaty. They worked on that, the International Law Commission. So they have had some success. They have helped us with the 58 Geneva Conventions, the law of the sea. They have helped us with the 1969 Law of Treaty, 1969 Convention, Vienna Convention on the Law of Treaties. And they have also helped us. Well, you haven't done that yet, I don't know if you have. The Vienna Convention on Diplomatic Relations, 1961, and the Vienna Convention on Consular Relations, 1963, based on drafts. They are working on one, doing similar work in the area of state responsibility. But they are having a little less success in this area than they had in the earlier cases. Why do you think this is so? Can you hazard a guess?
Because some states might not think that they're responsible.
Well, that's right. You see, on the area of state responsibility, as we were observing earlier, opinions tend to differ. You can't, in some issues, you can't really say that you have a consensus. When in areas where you have consensus, it's easy for the international because you have the practice, it's settled. And then all you have to do is to establish, determine the practice, identify it, and have it incorporated into the draft. But when there is no consensus, As we say, for example, there is deep division among capital exporting and capital importing countries on the issue of compensation. It makes it a little difficult for an international law agency. This is what it is. And that is why they haven't had that much success. However, they have done a lot of work. The drafts, they have a draft, ILC draft. That, of course, and over time, it will help to clarify the law because, of course, you will find tribunals, maybe the international court, referring to this. Any question? Any comment? So can we say that we're finished? We have wrapped up on our state responsibility? Candia, are you happy?
Very.
What about you, Luana? You're happy too? Samantha? You're not too sure whether you're happy or not. You better become happy, because remember, time is going very quickly. So, yes, any question? Yes, I have a question.
It's not really a question, it's a request. We were talking as a class concerning our paper, which is due on Friday, right? Most of us have started our research. And,
You want another one?
yes.
Take another. Take another one.
Thank you very much.
I was going to be a long speech, man.
You need to be unplugged.
You don't come here. I could have said to you, I gave this assignment, the second week. I said to you, look, don't leave this fight until the end. Don't wait. As you get the assignments, try to attempt them. Because what you're going to find coming to know is that you have a number of assignments to hand in. And you find yourself overwhelmed. Don't allow that to happen. What?